the sale agreement is not just a contract between a buyer and a seller. It also outlines the terms and conditions under which the transaction takes place. Unfortunately, many disputes arise between buyers and sellers, which often leads to costly consequences for one or both of the parties. Well, to shed light on the sale agreement, I'm now joined by two esteemed conveyancing attorneys from EYS Incorporated, Nell and Hannelie Hattingh. Hannelie, welcome to All About Property.
Thank you, Cornelius. We are honoured.
Now, let's get straight into it. And Hannelie, I want to start with you. The sale agreement is quite a lengthy document. What is the purpose of the sale agreement, and is it absolutely necessary for so many clauses in this document?
Cornelius, property, houses, contract law, yes, extremely important. Most people usually only buy property, two or three property during their lifetime, and it's a very important aspect to take all clauses, all relation, meeting of minds, getting to a point where you agree, what are you buying, what are you looking for? It's an expensive investment. And if you don't cover all the clauses, take fine consideration in what you are signing, you are stepping into a situation where you get emotional distress, a lot of financial expenses, and lost at the end of the day. When we buy a car, you do proper research, you go different dealers, you go and look at the make of the car, you ask for inspections. But with a house, some people, they're so excited in buying a house, they don't realize, what am I signing?
And they blindly trust.
And they blindly trust, and sometimes they get pushed, not aggressively pushed, but you will lose the property. So calm down, read.
Take your time.
Take your time. It's the biggest investment that you will make.
I love that. Una, we often hear the term offer to purchase. We also hear sale agreement.
Yes.
Is this the same thing?
Yes and no. Cornelius, people often refer to an offer to purchase, or they abbreviate OTP.
Yes.
So an offer is what the purchaser signs. The purchaser signs an offer to purchase a property from the seller. The minute that the seller accepts that offer, it becomes an agreement for sale. Okay. So what happens in some cases is the seller may not accept all of the terms of the purchaser's offer, and he may make a counter offer. He may change one or two clauses. So once again, not an agreement yet, then that is a counter offer. So the minute the purchaser then accepts the counter offer, then the agreement comes into play. The minute an agreement is signed, it's a firm agreement between two people, and it cannot merely be cancelled. It cannot be one-sidedly terminated, and from there, the conveyancers will then proceed to pass transfer in terms of that contract.
Okay, great. Now, Hannelie, there are very specific information that has to be in this agreement. Talk to us about this.
Yeah, we talk about the essential elements of a contract in the purchase of a property. So you will look at, you need to identify your parties. Who is buying? Who is the seller? Who is the purchaser? Then you have your purchase price, and the most important part is your property description. You can't just say item A or the blue house on the corner. Then you start putting a body onto your contract. You can't just have a pretty face and a smile and an expensive $sign. You need to say, what are we agreeing to? We need to get to we call it the meeting of the minds. We need to get on a mutual agreement. I'm buying this from you. What is in the house? What am I buying inside the house? It's only the shell. Will you renovate? Will you paint it? Will there be a mortgage bond? How long do I have to get a mortgage bond? Electrical compliance certificates, very important.
Building plans.
Building plans. So you need to agree. You can't just assume the seller and purchaser will accept everything as it is. You need to build, what are we agreeing on? Am I getting just a shell, or are you giving me the couches as well?
And I suppose that's why there's the segment in the agreement that says special conditions, and the purchaser get to fill that in.
Yeah,
correct.
So if I can just maybe come in here. So under our Alienation of Land Act, an agreement for purchase and sale has to be in writing, and it has to be signed by both parties. Electronic signatures are not yet acceptable. It has to be in wet ink. We say wet ink, just for people to understand it a little bit better. Most contracts contain a counterparts clause, so it doesn't matter if the seller is signing in Timbuktu and the purchaser is sitting in Pretoria. They can sign on two different versions of the agreement as long as it's identical in the end. Then it will be deemed to be one complete document, the two together.
Hannelie, we often hear the term a contract lapse or it's been cancelled. Is there a difference between these two terms, and does it have an implication for the buyer or the seller?
Yes, the lapse usually deals with your suspensive condition that we referred to earlier. Suspensive in the sense of the contract is pending for a period until a special condition has been fulfilled or succeeded. For example, your mortgage bond approval, if I don't get it within 10 days, it automatically lapses. There's no force and effect, nobody can be held liable unless if the purchaser did not go to the bank and apply for a mortgage bond.
So he should have done his part before it lapses.
Before it lapses. We usually start diarising from 5 days. Have you? And then we usually try and rescue the deal. So listen, we are now on day 2 before lapsing. Let's enter an addendum. Let's communicate. Let's negotiate to extend and see how we can push it to make the sale successful.
So an extension is possible?
It is possible, yes. Cancellation, that's the part nobody likes, but sometimes it happens. It's unfortunately, we're in an economy where anything and everything can happen. But the cancellation part is where danger starts arising. It's detrimental for the seller, detrimental for the purchaser. That's now where you had an obligation to perform and you did not perform it.
Costs have been incurred.
Yes. Costs have been incurred, you're quite far ahead, and all of a sudden say, no, I want to buy a car instead of a house. The seller will then place you on breach. The attorneys will deal with the letter of demand saying, in terms of your contract, you did not perform. You have 7 days to remedy it. You have a period to remedy it. But if you do not remedy and proceed with the transaction, that's when the legal implication steps in. The seller will then have an option either to cancel the contract or hold you liable for the damages occur or force you to proceed with the transaction. That obviously then entails probably going to court to force you to proceed.
And I guess the seller can also
claim damages.
So
they can claim the actual damages. So some contracts do contain a rookkoop clause. So some purchasers may even lose a deposit completely. In other instances, the seller will have to prove their damages. But the damages can include even if they have to sell their property at a lower price at a later date. That could form part of their damages. So it can be a huge impact. Same with the purchaser. If the seller has seller's remorse and tried to cancel the agreement and is now placed into breach by the purchaser also has damages. They've already given notice where they stay. They've maybe already arranged for a move. All of those expenses will be for the seller's account at that time. So just to be clear, as conveyancing attorneys, we can do a letter of demand against the defaulting party. But unfortunately, we can't take it further after that fact. Because in a transfer, we have to act in the best interest of purchaser and seller, so both parties are our clients. So then we will be in conflict of interest, and the purchaser or seller, depending on who the aggrieved party is, will have to seek other legal advice from there on.
You want to make sure that you consult an attorney, a conveyancing attorney, not just because your friend is an entertainment attorney, approach him. Speak to a conveyancing attorney before you sign on the dotted line. Chat to us about that.
The important thing is to get to a point where the contract that you are entering into conveys what you need. What do you need the property for? Do you want to use it for residential purposes? If not, is the zoning correct? Is the building plans updated? Building plans is a big issue these days, and more purchasers are asking for building plans, which is great. It's fantastic because we need to make sure of all of those facts. So we always say to a purchaser, if you are not 100% sure, if you are not 100% sure, but you want to tie up the property, then let's put in a due diligence clause, for instance. Give you time to do your due diligences in terms of the agreement. Have you decided when you want to move out of your property and into the new property? Can we try and negotiate that with the seller? I come back to occupation a lot because we battle with that aspect quite a lot. You don't want the purchaser to sit in a moving truck in front of the house and the seller is still inside. They haven't moved out as yet. So there's a lot of aspects that go into a property transaction, and if we don't ask the correct questions, you don't get to the correct result, unfortunately.
Now we almost have to go to an ad break, but just lastly and in closing, Una and Hannelie, you guys are conveyancing attorneys from EYS Incorporated, and you're situated in Pretoria East.
Yes.
Tell us a little bit about the offering or services at your firm.
Yeah, Cornelius, I don't even want to say how long I've been a conveyancer, but yeah, both Hannelie and myself are conveyancers. We are also notaries public. So we can offer a client basically everything. We can do from a client's antenuptial contract initially when they start their process in life to transfer of properties. We are also on most of the bank panels for bond registrations. Luckily for us, and we are very proud and we enjoy what we do, we are also quite proficient in development law. So we can do township registrations, opening of sectional title registers, subdivisions, consolidations. We can literally assist a client with everything from A to Z. Our litigation department is also a property litigation department. So they also specialize in property law, which is also great. It's fantastic. We can help a client through the whole process.
I love that. I love that. Well, Una, Hannelie, thank you so much for your time today.
Thanks, Cornelius.